will be properly met. And the day it happens, you can take it from me, the legal profession itself will be a great beneficiary. Because if the district courts are empowered, if the tribunals are abolished, and courts have plenty of work, you will find that the legal profession will be able to find new avenues for constitutional growth. And I think this is one of the major challenges. We are looking at what is called a vertical judiciary, and a pyramidical judiciary is really not what was contemplated by this constitution. But what has in fact happened is a pyramidical judiciary. So I personally think that if you go by objective records, I can show you in my career, I have seen 5 judgments in criminal cases where I think that the judgments of the sessions judge were superior to the judgment of the High Court, superior to the judgment of the Supreme Court. So it is a question of cultivating a measure of self-confidence, independence in the trial court to be able to do the right thing. But one must never punish a judge for an error. This we must understand. Because it is human to make a mistake. And we must give that freedom to make a mistake. Because nobody can be judgmental about a judge making a mistake. Because a judge also is a human being. At a given moment, you don't know what is working in his mind in terms of appraisal of evidence. And in the present scenario, where you have a huge number of cases, I was very horrified to hear that in one case relating to the liberty of a person, a judge did not sign the bail order for 2 weeks. Now that is something which is outrageous. And these are the things which must concern us. But errors sometimes can happen. There should never be a punishment for correction through an appellate process. The appellate process is meant to be a process of correction. Thank you.
Sir, I pay my obeisance to you and to all the dignitaries seated on the dais. I have a question which I want to ask through an example. So for example, when a person alleges a judge of some wrong and politicians comment for his resignation, even before proper probing has been done into the matter, does it not amount to contempt of court because the politicians are making or humiliating the judge without any proper proof in front of them? They are humiliating a component of the Indian judiciary. Does it not amount to contempt of court or any wrong on their part?
Well, you see, contempt of court is something which one must not easily get drawn into. But yes, maligning the judiciary without evidence is completely unforgivable. I must tell you this, and we must understand that in our country we will become a banana republic if we start actually acting on the basis of allegations, rumors, second-hand evidence. I will tell you, you've raised a very important question. This is not only true of legislators, which you mentioned, or politicians. It is also true of judges. Even judges sometimes act on the basis of rumors, and it is very wrong. If I were to tell you, as a law officer with some experience, I have seen with my own eyes that if someone decides that a candidate must not be appointed as a judge of a high court or the highest court, multiple methodologies exist in governmental bureaucracy to ensure that the person is not appointed. You have something called this Intelligence Bureau. I don't know how intelligent it is. It is a very important component in our governance. Then you have a system of complaints, and what is done is that a file suddenly emerges. It is almost a huge file of multiple complaints written by fake people and wanting to make sure that the person is not appointed as a judge. It is, I think, these are things which you must know actually happen in real life. So the reason why I mentioned about independence of judiciary is that we have to act with some degree of evidence also. We are lawyers. We are also meant to act judicially. You cannot argue on the basis. Somebody can actually float a rumor. Somebody can say an allegation. I think it's a very good question, but this applies not only to politicians. It applies to all of us, even as law students, even as lawyers. One of the first things, and I want to share that with you, and I hope it makes some amount of, it appeals to you. One of the first things which I learned, and that is when I met Sir S.M. Bose, and I have never forgotten what he said. He said, a judge is never meant to be discussed or commented. And I was wondering that why was this cryptic line? And later he explained, you must know as a lawyer that all that matters is your own ability to perceive. And you have to perceive. Without your perception, you cannot rely on second-hand, third-hand, fourth-hand perception. And this is very necessary for the legal profession. And the reason why today we can still say that we have an independent judiciary, which has its own faults. I'm not for a moment saying that it doesn't have faults. It has faults. But we still have an independent judiciary because the legal profession understands that no, it is not mere allegations which work. What works is proof. What works is evidence. What works is some material. And we have to learn to know that we are ultimately going to determine what is true. To ascertain truth is the job of a lawyer. And as law students, the best, I mean, it's a very good question again. We have to act only on evidence. It's a great lesson. It's a lesson which I have learned the very hard way.
So may I make a humble submission?
There's one question, I'm sorry, the second question. Please, go ahead.
Yeah? So we'll take the question batches of 3 maybe, because otherwise we'll be here all night. So we'll not...
I'm willing.
I just want to know your opinion for my own knowledge. That is, what was the difference of the powers of the High Court judiciary before the Constitution came into being and after the Constitution came into being vis-a-vis the subordinate courts? And number 2, do you believe that the subordinate courts had more powers than the High Court before the Constitution came into being, with special reference to the L. Chandrakumar versus Union of India 1997 case?
L. Chandrakumar is a case relating to creation of tribunals and whether judicial review under Article 226 could be taken away by tribunals. And it was held that it cannot be taken away. And I don't see any point in having a tribunal and then go to the High Court. It's a waste of time, it's a waste of money, and government wastes a lot of money. If you see the number of cases which are filed by the government against judgments of the administrative tribunal, which is meant actually to relieve the docket of courts, you will be shocked to see the number of frivolous cases which are filed, and they are meant to hang there for 5-10 years because some people have to be deprived of their rights. So, tribunals, Chandrakumar was a decision in the context of tribunals. As far as subordinate judiciary is concerned, subordinate judiciary did have a very primary place even prior to the enactment of the Constitution. But the reason why the Constitution provided specially for subordinate judiciary is that it wanted subordinate judiciary to be a part of the constitutional judiciary. Please don't ever think that subordinate judiciary is appointed by virtue of rules framed under Article 309. It's a very big mistake which many state governments make. It is not proper to treat the judicial service as a service of the state or the union under Article 309. This is a service which is relatable strictly to what is called Chapter 6.
Sir,
Yes.
Sir, is there any derogation of democratic right in contesting the election of the legislature by the retired Supreme Court or High Court judges?
In my view, any retired judge must not stand for election in the political fray. A judge is essentially apolitical. And if you take oath as an office of a judge, you have committed yourself to a way of life to the end of your life. As simple as that. If you don't have that courage, you must never become a judge. But it is utterly improper for a judge after his retirement to stand out as a candidate for a political party and bring, should I say, the judicial office into disrepute. I must tell you, we were all utterly disappointed when we saw that a judge of the Supreme Court resigned and quickly was appointed as a candidate to the Rajya Sabha by the Congress party. We were horrified. And we said that why did he at all become a judge? And for 2.5 years, hold the office as a judge, resign, and then become a member of parliament to do what is called public service. It is absolutely unacceptable. The two spheres are different. The sphere of public affairs through legislature is completely different from a public service as a judge. The two conflict, and one cannot travel in conflicting zones in one's life. It is much safer not to. At least one more question. It might be the last.
Thank you so much for all your enlightenment facts and everything. My question is, today our topic is independence of judiciary. So judiciary includes the subordinate courts. Now, the way we talked about how judges of the Supreme Court and High Court are appointed, but my question is relating to the appointment of subordinate courts. I mean, we have a system of judicial service, examination, and then those who can fare well, they become the judges or the magistrates for that matter. But we are all students, we know how to crack exams. You know, some people also know how to mug up all the lessons and go and just, vomit in the paper. So we know, as students, we have all mastered the art of passing our exams. But
I have also mugged.
So, as judges, what we need is experience and that passion to actually deliver justice. What I have, it is absolutely my personal opinion, is that if judges are selected by way of examination, what is happening, parents are pushing their children to judicial service because it pays more, you have respect and all, but that passion to actually deliver justice, that determination to work for human goal is missing. As a result, my fellow, another member also brought up this point that more than often it is noticed that judges have delivered a wrong judgment because of which, litigants have been facing so much of, in terms of monetary loss, time. So how are we to combat that? I mean, in your opinion, is this way of selecting judges is very correct?
I'm simply, shall I say, I'm a bit stunned that in an audience of students, you're all claiming yourself as students. I hope you are students. To ask this very, very incisive question. It's a very profound question. And it's the heart of this matter. At least, if there is something by which I can say I have delivered a worthwhile lecture, it is this question which gives me that indication. What I spoke about and what you rightly captured is the passion for justice. It is a matter of passion. And mind you, I spoke of Bangalore principles because that's what we're all taught in academic literature. Bangalore principles are, you can call them by any name. But actually, you have hit the nail on the head. The judge is one who has a passion for justice. Select a person who has a passion for justice. Actually, this requires very, very strong insights into the human personality. You see, a passion for justice is to be able to stand up. I'll give you an example. You are walking on the road. You find that somebody is being beaten up, and you can see something is going wrong. If you are a lawyer and you don't intervene, it's no use studying law at all. But if you intervene, it shows you courage. But why is it you're intervening? You're not intervening because you're a busybody, but you feel that you need to intervene when something is outside the line of normal human behavior. Passion for justice is when you want to do the right thing. And I can tell you, when you have a passion for justice, and you can have it even as a lawyer, it is not necessary that it is only a judge who has a passion for justice. Even as a lawyer, you must have a passion for justice. But it is something which keeps you going like adrenaline. That is, if you have this passion, you will skip your breakfast, you will skip your lunch. What will keep you going is only a sense of satisfaction. I started my career, by the way, in a beggar's court, in a magistrate's court. That's something which I'm very proud of. And that gave me the first interface with poverty, and true poverty. And I saw that people are put in jail because they are begged on the street. And we are actually a country, we claim India is shining, and our GDP and our FDI and FII, and you find lots of lovely noises about our economic growth. But we still, in the capital of India, you will find very near Kingsway Camp, there is what is called a detention home, where for people who beg, those children are taken and whisked in a van and they are detained for weeks without being produced before a magistrate. So much so for all our claim to human rights and constitutional freedoms. So I used to go.
Illegal by Justice Badr?
Well, in spite of Justice Badr Ahmed declaring those provisions illegal, as I said, our executive is so obedient and so respectful of law that even now they round up in a blue van people on a daily quota. They're picked up and put in detention. And it is only when I appeared for them I realized what happens when you need to furnish a surety. Now there's a young man who is impecunious. He can never furnish any surety. How to trace that person? So we worked with some of the